Hello, I'm Philip Sales. In this video, I'm interviewing Michelle Dyson, a government lawyer. We'll be speaking about the detailed development of policy proposals for legislation by a government department. Michelle, we've reached the stage where the department has worked up a policy, the minister is happy with it, and it has been cleared by cabinet. What happens then?
Well, you're really entering the detailed phase of the process, and the critical part of that is instructing Parliamentary Council. This is the lawyer's role. Policy official has a supporting role to play, but the lead now moves to the lawyer.
Who are Parliamentary Council? What do they do?
Parliamentary Council, they draft primary legislation. They don't draft the secondary, or on the whole they don't draft secondary legislation, but they draft primary legislation. So all bills will be drafted by the Parliamentary Council.
So they're drafting specialists, is that it?
Yeah. So the lawyer has to draft instructions to Parliamentary Council, which have a reasonably sort of specific format. You have to set out all the background law, the existing law in as much detail as you can. You set out the general sort of thrust of the policy, and then you get into the real detail of exactly what the department wants to achieve in as much detail as possible. And you would expect the process of instructing Parliamentary Council to be pretty drawn out. We call it a sort of iterative process. You'll send off your instructions to Parliamentary Council. They'll come back with lists and lists of questions about what do you mean about this, have you thought about that? You'll then go back, again the lawyer, but obviously in discussion with the policy official, because it's their policy, and this process can go on for some time. And see, a longer bill, you would expect it to go on for longer, but actually short bills can be pretty complicated as well once you start to dig beneath the surface.
And what emerges in this iterative process? What are you trying to achieve, and what's Parliamentary Council trying to achieve?
You're trying to achieve a draft bill. That's the sort of product. But in terms of the policy, you're really trying to sort of get underneath it and look at all the issues and make sure there are no unforeseen consequences of what you're proposing.
So can you give us an example about this process in action?
Yeah. Well, a few years ago I worked on a bill, the Female Genital Mutilation Act of 2003, where this was a relatively straightforward, well, a very straightforward policy in principle. Ministers felt very strongly that we had criminalised the act of female genital mutilation, but the evidence was that people were taking their daughters abroad to have the operation performed. So the proposal was criminalise taking your daughter abroad to have this operation performed. But once we started sort of developing this policy, it became clear that if you just made it an offence to take your child abroad, then there'd be endless loopholes around that. And what happens if you can prove that you actually took your child abroad for a holiday, but oh, by the way, this happened to happen while you were there? Or what happens if you put your child on the plane but don't actually take her? Or what happens if you find someone else to take her, and that person doesn't know anything about what the purpose is, but nonetheless they're doing the taking, so it would seem wrong that they should commit the criminal offence, but the person who you would want to cover would be staying at home and therefore not taking their child. So what we ended up doing in this case was we reverted to sort of age-old criminal law concepts of aiding, abetting, counselling and procuring to try and cover all those sorts of, the person who stays at home just organising it would be covered by that. So that's the sort of thing where you're trying to get underneath what the policy is really driving at.
So did you try different alternatives and then came back to aiding and abetting?
Yeah, I think it was a case of, in this case, just sort of sitting around the table and talking through all the different scenarios that we would want to capture and working out what the best way in law was to cover those.
What happens with a complex policy which you're trying to implement? Can you give us an example of that?
Well, there's another one which come to be known as familial homicide.
What does that mean?
What does that mean? It's the case where you have classically a child who dies, and you know that they've been killed by one of their two parents, or maybe the mother and the mother's boyfriend, because of the circumstances of the death, it's occurred in the house or something, but you don't know who did it, and neither, you know it's one of the two, but you don't know which of the two, and neither will implicate the other. Until we created this new offence of familial homicide, you could get the two of them for child neglect or child cruelty, but you couldn't actually get them for the death. So no one, you know, clearly have a child who suffered an unlawful death, and yet no one's being prosecuted or convicted for that death. So what we came up with was a fairly novel offence, whereby what we said was, if you have a child at risk and you have two people in that household and the death of the child is foreseeable, which it usually is in these cases, because you've got a child who's, you know, where social services are involved and lots of injuries, then if the child then dies, then both people are responsible for the death on the basis that either they killed the child or they should have prevented the death. And the novelty about this offence was that we specifically provided that the prosecutor didn't have to prove whether they killed the child or should have prevented it. Because of the circumstances, you know that they are in one or other of those categories, and that's enough to get them for the death.
So either would be sufficient for them to be convicted.
Yeah. And in fact, there have been quite a lot of high-profile cases where people have been convicted for this, and notably the notorious case of Baby P.
I see. So
it's worked.
The mother and the boyfriend in that case were convicted of this offence for the death.
Yeah.
Now, what sort of, at what stage do the knotty legal problems have to be worked out?
Well, you would be wanting to get underneath them right from the start. You know, if you've got a human rights issue that's crying out at you, you would want to address that right from the start. But often they don't actually come out until this stage, when you're really into the in-depth detail of the policy. And you might well find that at this stage you run into issues, classically the human rights ones. You might even need to go to the Attorney General, who's the government's chief legal advisor. We never say in public when we go to the Attorney General, that's convention that we don't. But you might well, if you've got a sort of big, say, human rights issue in relation to a bill, your minister might well want to involve the Attorney General.
And is that to get an authoritative legal view within government, what the legal position might be?
Yes.
Now, there's a practice of pre-legislative scrutiny. Can you tell us what that's about?
Pre-legislative scrutiny is scrutiny by Parliament of the bill, but it's before it's introduced into Parliament. So it's before it goes through its sort of proper parliamentary stages. And the purpose is to give Parliament a chance to scrutinise the bill with the assistance of interested parties. I mean, they'll tend to take evidence from people on the bill and then prepare a report at the end. And the idea is that gives Parliament a chance to influence the development of the policy before you introduce the bill into Parliament.
So is there a draft bill on the table which
Yes.
Parliament is looking at that stage? What is the role of officials in this process?
It's quite hard work for officials, actually, pre-legislative scrutiny, because what you will have is you'll have a committee, a parliamentary committee that's set up to look at the bill. It will take evidence from a whole range of people. Officials will probably go to those evidence sessions so they can see how things are developing. I mean, you would hope that officials have actually engaged with all those people and know what they're going to say in advance. One of the evidence sessions will be with the minister, and officials will need to prepare the minister for that session. So the minister will want detailed briefing on everything, and he'll want meetings with officials. And then officials will often sit with, or the lead officials will sit with the minister as he's giving evidence, and in some cases take questions themselves.
And what materials does the department prepare for pre-legislative scrutiny and to provide to the committee?
It would just depend on what the committee wants, but obviously it will have to provide the bill and the explanatory notes, which, as it sounds, are the notes that explain each clause of the bill you'll also need an impact assessment, the document that explains the costs and benefits of the policy. Behind the scenes, there will also be a memorandum that sets out the human rights position, what the department the department's analysis of the human rights compatibility of the bill. But you won't actually provide that to the committee. But it's an important document for internal purposes, because eventually the minister, before the bill is introduced into Parliament, is going to have to sign what we call a Section 19 certificate made under the Human Rights Act 1998 to assure Parliament that the bill is compatible with the European Convention on Human Rights.
And how effective is pre-legislative scrutiny?
It can be very effective. I mean, I actually worked on a bill that's slightly sort of infamous, because there was the corruption bill, where the report of the committee was not good, and we ended up not taking the bill forwards. I don't think that happens very often. More often, you will get the committee being critical of bits of the policy, and although that doesn't mean you then have to change the policy, you'll be on the back foot when the bill is finally introduced into Parliament if either you haven't changed it, or you don't have a very good explanation as to why you haven't changed it.
And what makes pre-legislative scrutiny go badly? What factors contributed to the corruption bill, for example, being criticised?
I mean, I think in that case it was because the bill covered too much behaviour. It was making too much behaviour corrupt, and it was probably right that they were critical of that. I think also engagement with the people who are going to give evidence beforehand, so that they understand where the department is coming from. So you can have proper dialogue with them is really important, because then you know where they're going to be. You know what bits of your bill are likely to be criticised, and you have a chance beforehand to actually discuss that with them.
And what sort of people will give evidence to the committee at the pre-legislative stage?
Really anyone who's interested. I mean, I think what usually happens is the committee will look at the people who've written in at the time of the consultation. That will give them a sense of non-governmental organisations who are interested. If it's a law commission bill, you would expect the law commission to give evidence. Really, a whole range of people.
And the committee which is set up to look at the bill, is it set up specially for that bill, or is it one of the standing committees in Parliament?
It varies. It can be set up specially, or it can be the standing committee with responsibility for that department.
In our next video, Michelle will be explaining the role of officials in handling the passage of a bill through Parliament.